Good afternoon, everybody. Just a few items of housekeeping first. The committee dealing with the application consists of, on my right, John Mann, and on my left, Lyle Cox, and my name is Chris Cooney. Whilst the hearing's in session, feel at liberty to leave the room if you want to, but without making undue noise. And please ensure that you don't make comments whilst other people are giving evidence. You'll get your opportunity, anyone that's objecting, to do that at a later date. All phones should be switched off, please. We aim to be finished by 8 p.m. this evening, if that's possible. We'll be finished by then. So I'll call the meeting now to order. And Mr. Young, you're going to present submissions. So you've made 3 sets of submissions and evidence. The people giving evidence will need to either swear an oath or an affirmation. And we'd appreciate it if they could be succinct. A lot of the evidence that you've written out doesn't need to be addressed orally. So I leave it to you.
Yes, no, thank you, sir. All witnesses, Mr. Christensen is here to your right, my left, and we have 3 witnesses sitting behind Greg Hoare, Michelle Given and Alan Mackay. They've all been prepped to give a summary, because your directions here will be taken as read, and hopefully that's 2 or 3 minutes, it might be more. Just in terms of the order in your note, your agenda today, if you're happy, sir, I propose to call Mr. Christensen first, because he's got the lion's share of the evidence, then probably Mr. Hoare on the Training Systems and Support Office, Ms. Given and Mr. Mackay at the end, because really he's here just so a director is present at the hearing. Are you happy if I run it in that order? So with submissions, sir, I plan on speaking to them as well. I might come back to some with closing remarks on the final day or in written closings.
There are 3 submissions you've made.
I thought I only had 2, sir. You said 3. But I've got certainly opening submissions in a supplementary set.
Yep.
You got to call for appearances from the others here.
Oh yes. Just before you start,
Can
I call for appearances from any other people acting as objectors, or the Ministry of Health, or the police?
speak up and tell us who you are, that's all.
Sergeant Kim Churnside for police.
Sian Swinney, Licensing Inspector, to assist.
Dr. Michael Butchard, Medical Officer of Health.
And Stephanie Becker's Pay here to assist.
Kia ora, Dr. Miss Gordon, Council for Ms. Lisa Riley and Ms. Lisa Riley.
Thank you. Thank you. Thank you, Mr. Young.
Thank you, sir. If you have my first set of submissions in front of you, dated 25 September 2025, I'll just speak to some aspects of those. I won't go through the introduction or the key aspects of the application, because you'll be familiar with those points. But I do note at 2.1D, when we talk about potential impacts on amenity and good order, I've noted there the absence of a bottle store in Lake Hawea currently, KHL's commitment to maintaining amenity and good order. It addresses the sensitive sites and notes that this is a commercial zone, a local shopping centre zone. Mr. Christensen also presents deprivation data that indicates this isn't a vulnerable community on that metric, and reaches the reasonable conclusion that the amenity and good order of the locality is not already badly affected by the existing grocery store, supermarket off licence and the other grocery off licence in Hawea. Turning now to the evidence of Mr. Christensen, I say he provides a detailed and comprehensive statement of evidence, and I won't step through that. He addresses the historical CPO failures. Sir, I will touch on, you'll be aware of a ram raid at Remarkables Park on the weekend. Mr. Christensen's here to answer any questions about that, but to give you an overview of the position for the applicant in relation to that incident, it's unfortunate. No one wants it to happen. The police have responded quickly and appear to have apprehended those responsible, and the applicant cooperated with the police as fully as it could. The store was remedied and ready to trade at 9 a.m. on the day of the incident, so the community wasn't exposed to the damage that had been done, so there was hard work and a rapid response by KHL to remedy the damage. Their staff are all okay. There were no staff present at the time, but the incident still causes some alarm or concern for staff, but the staff are okay, and there's been a significant number of the community reaching out to support the applicant. And Mr. Christensen can speak to this and give you an update on that. And the final point, and probably the most important, is there will be learnings. One of the issues that seems to have emerged is there's quite a steep curb, and there was some confidence that a car couldn't mount that curb. Well, it did, and therefore additional bollards will be put in place. And learnings that are gained from this experience will be applied to the Hawea premises as well. So I thought I'd just, because I touch on the CPOs, there's been that incident, you'll be aware of it, and it isn't in written evidence, but we're here to assist you with it however you need. I won't go through all of Mr. Christensen's evidence, but what I do want to highlight, if I get to 2.11 in my submissions, I want to take you to his rebuttal statement. And just in terms of character and integrity, if I can take you to paragraph 11.5. This is his statement dated 28 October 2025. It's the rebuttal statement. And there's a theme in the objections about community engagement, community spirit, knowing your community, being community minded. I could frame it a number of ways. I just want to take you to 11.5 where Mr. Christensen acknowledges that his employer KHL allows him to do a number of things as part of his community engagement, including being on the board of Hospitality New Zealand, Central Otago Resilience Trust, a trustee on the Cornwall Primary School, and I won't go through all of them, but there's a significant list there of community engagement, and you'll also see that the Gate Group itself supports numerous schools and organisations. So I just want to emphasise this is an organisation, and the individuals within it are community minded, are engaged in their community, and would do so in any community where they served. And I don't think there can be any question that these people aren't people who are community minded and care about the communities they operate within. I've summarised Mr. Mackay's evidence, Ms. Given's evidence and Mr. Hall's evidence at page 4. Then I come down over on page 5 to the objectors and MOH. I've touched there on the inspector's report at 4.1, which summarises the objections. But if I go over the page, I move into this topic of community engagement and I get to my first case. And this is the Rosedale liquor case, decision of the authority of a recent decision concerning a new bottle store in Rosedale and Albany. And in terms of community engagement, what the authority said in that case was, we accept, as did the DLC, that the respondent had not engaged with all sections of the community, including Māori. It was not, however, obligatory, and the level of engagement with community is a factor to be weighed in the assessment of suitability. And then what they go on to say is that it was a decile 3 area, and so concerns about vulnerability weren't significant for them. And then the authority, different judge, Judge Spear, their previous decision was Judge Menzies, who's now retired, but Judge Spear in the Huntley Grocer decision talked about community engagement, and I won't read the entire section, but if you turn the page to page 7, look at paragraph 28. Furthermore, we do not accept the specific complaint made by Mr. Hewison that Ms. Martelli had made no attempt to engage with the community before the application was made. And this is the kicker, the key part of this. There is no requirement or even an expectation and that an intending applicant for a licence engage with the local community before an application is made. The purpose of the requirement to give public notification of the application is to provide the local community with the opportunity to respond to it, including by way of formal objection. So I'll say two things to you. This is an organisation that understands its communities and understands this community. However, the suggestion that they somehow have to engage with the community before they lodge an application is not what the authority has said. And I'm not entirely sure why these decisions aren't addressed by those who make that claim, because they're recent decisions and they're well-known decisions. At 4.5, I just take you to Rosedale again about template objections. You'll know that a number of these objections, the vast majority, are on a template form, and the inspector has helpfully given you that template form in her report. And what I say here is the authority has expressed significant concerns about template objections, and this is Rosedale again, where Communities Against Alcohol Harm were involved in generating objections. And what the authority says is, first, they confirm that we think Ponder remains good law, and that is, if there is no reporting agency opposition, objectors have a high threshold to establish a lack of suitability or impacts on amenity and good order. So that's what Ponder says. But in this case, the appellant, the objector, claimed that that was no longer good law because of the reforms to the Act, the Community Participation Act. And the authority said, well, we think it is good law, and that is particularly so because the Amendment Act appears to have generated the increased use of pro forma tick box objections prepared by a group or groups, potentially with their own agendas. Such objections suffer from a lack of author authenticity and are likely to carry less weight. Now, what I would say at that point, though, sir, I can assure the committee that my client is here today with an open mind and here to listen. The difficulty they are confronted with when they receive these template objections is they don't really know what a person genuinely thinks. Now we have evidence, and we have evidence from objectors saying this is our concern, then you can engage with that and listen to it. You may not be able to fix all the problems or alleviate all the concerns, but you can try. And so whilst I, as a legal advisor to the applicant, have some difficulty with the template objections, the applicant is here with an open mind. The applicant is here to listen and engage and see where that lands. Now, the Medical Officer of Health, I deal with at page 9. I say the reporting is problematic. I think it's best I leave that for a closing submission and we hear from the MOH, see what you ask, and I come back to that. I do make the point there, though, Ms Gordon deals with this in her submissions. The Section 100F building consent issue in my submission is a red herring. The DLC and the inspector have dealt with it and accepted the application as full. It is common practice that people will seek a licence before building consent, and as my friend acknowledges in the Big Barrel decision, the authority has condoned that practice. But I've been on the other side of the fence, sir, where I've been at hearings and my clients have built a bar and they've done everything and they've had objections and they've been accused of being cocky and presumptuous because they built something without a licence. So you can't win either way sometimes, but it's quite logical to say, well, if we're going to build a purpose-built building, in terms of storage, lighting and all of those things to make sure it's a safe and a good building to operate this sort of retailing in, we won't spend all that money until we know we have a licence. That's completely reasonable. They've invested the money already in a resource consent. You need the consent. You need to prove that you can get planning permission, but building consent follows. And so in my submission to that, it's a red herring. It's probably a procedural matter that if anyone wanted to take it, they'd have to go to the High Court in a judicial review proceeding. I'm not encouraging that, of course, but I think we need to put that issue to one side. And of course, you have mock-ups, you have an internal layout, you can look at design and layout, you can assess whether someone can see into the chiller, where the CCTV is, where the customers can be seen, where the cars outside can be seen, and the answer to all those things is yes. And Mr McDowell was able to do a set-tiered checklist based on that information. So on my submission, you can certainly evaluate the application under the design and layout criterion. Now, coming to relevant statutory requirements, section 105 guides your evaluation, you'll know that, and I just note there that section 106 is a guide as well to your amenity and good order evaluation, which in this case will be whether there is a risk of a more than minor impact on amenity and good order. But importantly, proliferation, and this is the issue, that one new outlet or one new store must inevitably cause harm just because you're adding another licence. That's not a statutory criterion. And that's important because in the Selby decision in Otaki, there was one bottle store and another one being added, and much of the case was with, well, another one must cause more problems. And what the authority said about that, citing the Gisborne Liquor Mart, and it's over the page, the proliferation, it's the top of page 11, the proliferation of outlets is a legislative aid for the DLC when forming an opinion. In itself, though, proliferation is not a ground for objection without some discussion of the effects or impacts. So you can't just say another one's bad. You have to say why, and you have to explain what is the risk and what you say may happen that is adverse. Mandatory conditions are set out at 1162, and I should note at this point too that the applicant also has an open mind around conditions. There have been some suggestion of single sales conditions. The authority has pushed back quite hard on single sales conditions in recent times through the Huntley Grocer decision, but we're here to listen, engage and see what might work in terms of an appropriate suite of conditions, not only for ourselves but for the community or for the enforcement agencies. I don't need to take you through Bella's or Malone's, but I'll take you to relevant legal principles now at 6.1. And I just note that the Act, and we do need reminding of this, it isn't a prohibition statute. We must minimise harm, we don't eliminate it. And I just cite Justice Moore in the birth care case. At 6.5, sir, I think this is important in terms of evidence and the generalised evidence, that generalised evidence will not establish a real risk of harm. Now, that's your evaluation, not mine. But at 202 of the Town Hall decision, and that's another decision I understand Communities Against Alcohol Harm were involved in, and it's a recent decision, but it's not addressed in any submissions for the opposing parties. At 202, sorry, what it said is, while objectors may feel they ought not to have to be exposed to any risk of alcohol-related harm, the Act seeks to strike a balance through the requirement to consider the criterion 105, shored up by there being no presumption in favour of renewal of a licence after the first probationary year. So this was a new licence in Amberley. There was an existing store, existing super liquor, and I think this was a thirsty liquor. So a second store in a town in the Canterbury region. And then that point is, if you do get a licence, you get it for 1 year. You don't get it for 3, and they call that the probationary first year. So therefore, if there were concerns, but the committee felt the evidence wasn't strong enough, that those were perhaps supposition, but they do emerge, then there's no presumption that your licence will be renewed. And the authority has moved more and more to that. You get your first probationary year. If you don't do what you said you'd do, or the problems or the concerns that the objectives have raised arise, then your licence is in jeopardy on renewal. Amenity and good order, I just refer to the Venus decision about no one has to prove anything. That's the same with every criterion under the Act. It's an evaluative matter, so no one has to prove that there's no impact. You simply put all the information into the pot, weigh it up, and what is the risk profile. Suitability, I refer to Capital Liquor. I do note the inspector has no issues with the suitability of the applicant, and I'm to some extent surprised there's any challenge given the credibility and credentials of the people involved with this organisation and this application. But Capital Liquor, now I'll take you to the end of this case, they didn't actually cancel the licence, they reduced the hours. But some of the things that occurred, so this was on Courtney, at the beginning of Courtney Place, right by the entrance that you head into, basically down to the strip in Courtney Place, where Molly Malone's used to be. So a little bottle store, and there's a pocket park across the road, because 2 roads intersect, you've got a triangle of land. The chap who was running that bottle store was found drunk behind the counter when he was working. So this is the kind of extreme behaviour that obviously drives straight to suitability, and you'll see that in those facts there. He'd failed CPOs at that store. You could see people drinking in the pocket park across the road. So you've got real red flags here. He had his hours reduced, but the licence wasn't declined, and he retained his manager's certificate because he did make some remedial steps. He took some steps to improve things. So to suggest that somehow Mr. Christensen or his team aren't suitable because they don't live in Hawea is one of the grounds, or they didn't engage with the community in the way that some members of the community might have wished, I think is drawing a long bosu. Reasonableness, I just remind the committee that everything we all do, myself included and yourselves, needs to be reasonable. And that's remained good law for many years under both the Sale of Liquor Act and the Sale and Supply of Alcohol Act. Academic studies, this passage came from the Wellington LAP decision. It was the second LAP that the authority heard after the Tasman LAP. Interestingly, the council had tried to extend hours to closing hours to 5 a.m. for on licences. No one else had tried to do that. At that time, everyone had either stuck with the default or tried to reduce hours. And there was many public health experts giving evidence, but what the authority said about academic studies, and you'll see them littered through the opposition evidence, is that they basically don't help. The authority here is not, and this is a local alcohol policy, so this is not dealing with New Zealand, but it's dealing with Wellington. So you've still got a broader purview than a site-specific application in Hawea. And what Judge Hull said is, the authority is not dealing here with national trends, which is the province of legislation. So national studies informs the Act. But with site-specific or with specific alcohol problems, related problems associated with Wellington City. So then you come from national down to regional or district, and that's your local alcohol policy. In that context, Professor Caswell's evidence was of minimal value. And Sally Caswell's a well-known academic researcher in public health and alcohol harm. Professor Caswell did note that the availability theory was more obviously applicable to the on-licence appeal than the off-licence appeal. So in my submission, what that means, sir, is national studies, and perhaps even international studies of similar countries, Australia, Canada, would go into your, like the Law Commission report, and go into how you draft legislation. Then you might have a Wellington or a Clutha or a Queenstown specific study, and that might go in to inform your LAP. Then the bottom tier is the site-specific application process informed by the Act and by an LAP where it exists, but national studies do nothing to assist you to assess the potential impact of a bottle store in a specific community. And I'm comfortable that the authority shares that view because those national studies didn't even help it to look at an LAP for Wellington. I then touch on Ponder Holdings. I've mentioned that already. That's where there's no agency opposition. It's a high hurdle for an objector to overcome, but at the moment we do have MOH opposition. We'll learn about where that is focused as the hearing goes and what the specific concerns are, and I'll return to that principle in closing submissions, sir. Now I just want to move on quickly to my supplementary submissions, and I won't take too much longer, sir, because I know you'll want to get to the evidence. So those are dated 28 October 2025. One of the other themes you'll see, and it's a similar issue to the academic studies, is people or objectors or parties relying on the Law Commission report to say it somehow changes the plain words of the Act. Now the authority has said, no, that's not right. And in Rosedale Liquor, referring to Rickard and Bush, they said, the approach that all we have to do is look at the Act. The approach is consistent with the authority's decision in Rickard and Bush referred to previously. In that case, the discussion was about the Law Commission report, which addressed the extent to which outlet density could contribute to community degradation. The authority noted that that report led to the implementation of the Act, which in turn meant that there is nothing further to consider other than the Act itself. So those extraneous, the only time you reach out to extraneous documents is when the legislation isn't clear. And you might, as you'll know, you might go to Hansard's or political debates or select committee reports to try and remedy a lack of clarity. But here, Section 105 is clear. We all know what the criteria are. There's law around how you approach your exercise. So the Law Commission report or the Community Participation Amendment Act, they've done their job, they've gone, they've amended the Act, and that's where we focus. At 2.3, I have gone through the case law cited by others, and you'll see in terms of Venus, Vaudrey and Lion Liquor, those are all good cases. They all remain good law as far as they go. They are high level, the passages cited are high level, but I don't dispute those findings in those cases. Lion Liquor was in the middle of Wellington, quite a specific, again, at the top end of Courtney Place, and there was an issue with drinking in the New World car park, so that had quite a set of unique circumstances. The concept of preloading, side-loading, or tailgating as they call it, when going to the entertainment precinct of Wellington. You might drink in these car parks. So there was a heightened risk profile with that store. Vaudrey is a supermarket store, but a supermarket case, but that's still, the principles are relevant. Niches is interesting because that's relied on by the MOH. The general statements about elevated suitability or a higher standard in high deprivation areas, that's good law, I accept that, and Shady Lady says that as well. But Niches was in Cannons Creek. It was a bottle store on Fontaine Street, and I went and had a look at it when I did a case in Cannons Creek to have a look at the environment. There's a residential road with a school on one side, 3 shops, there was a takeaway, something else, and a bottle store in the middle, and the gate to the school park was straight across the road. And it was deprivation 9 and 10. Highly deprived area, highly vulnerable area, and the person operating the store wasn't doing it very well. So the first owner of the store eventually surrendered their licence because they reduced the hours right down and he couldn't make it work. The new purchaser bought it and had no knowledge of all the historical issues. And so the authority said, well, you're not suitable because you haven't engaged with this store in this community and with its problems. So that, again, we don't face those issues here. We're not in a highly deprived, predominantly Māori or Pacifica community adjacent to the school field where there was evidence of people just drinking on the street outside the bottle store. It was pretty horrific. So if you track that back and look at Fontaine Street and Cannons Creek, you'll see good law, but an entirely different factual matrix. Two brothers, again, in Tokoroa, high deprivation locality, high percentage of Māori. So it is good law in terms of the general proposition, but the other thing there is the licensee had MB investigating him for breaches of employment law. So again, the factual matrix is entirely different to what you're confronted with in this application. Dylan, I just note a footnote about the person's behaviour. The knowledge of the locality was described as abysmal. I think this is Ellerslie in Auckland off the top of my head. And then we get to Shady Lady, and all I note about that is, yes, that is good law, but it was a premise in a CBD, so the main central business district for the Hutt city area, and it was a destination for people living in the wider council area. But what is interesting and what the MOH don't refer to is in that decision, Dr. Stephen Palmer, who's appeared frequently before committees and the authority, said that the MOH can't really contribute much to the amenity and good order evaluation. So you'll see there, he said, Dr. Palmer considered that only a small set of health harm can be linked to problems associated with amenity and good order. And this is mostly exclusively confined to injury from assaults. And so what he quite reasonably acknowledged there is amenity and good order is probably the police are the lead agency, nuisance, disorder, vandalism, and the inspector as well. But when the MOH brings its public health expertise to bear, or to a hearing, it doesn't really speak to that issue, and Dr. Palmer acknowledged that. And then finally, I don't know if I've got the right footnote, but there's a decision called USEFI referred to by the MOH, and all we can find is that decision is about immigration and a discharge without conviction. It's not about some supply of alcohol as far as I can see. But it may be that there is we've looked for a USEFI in the alcohol law database, can't find it, and the ones we have found don't deal with some supply of alcohol. And then I note that the MOH submissions, and I can say also, my friend, Ms. Gordon, they don't refer to Rosedale. Recent case, dealing with deprivation, dealing with a new bottle store in a mid-deprivation area, similar factual matrix. They don't deal with it. They don't deal with Huntley Grocer. They don't deal with Selby, which talks about proliferation and how you've been to approach it. They don't deal with Townhill, which talks about generalised evidence, and you can't expect to just say something will happen and that be evidence in itself. There has to be some reasonable, rational basis for it. And nor do they deal with Ponder Holdings. And those decisions address community engagement, suitability and amenity and good order, which are probably the key elevated criteria in this matter. And I say to you that the factual matrix in Town Hall, and I think it's a critical case here, is very similar to the KHL application. So that's the case you would look at to take some guidance, but there's silence from the opposition on that. Then I would refer to the 2.7, there's two recent High Court cases, and I preempted that my friend Ms Gordon would refer to them. And I just wanted to briefly address you on them. The first one is Whitman Way. Interestingly, a bit of background on that, that was the first appeal ever heard by the authority under the new Act. And I acted for the applicant at that point. I had no involvement in this High Court matter. And what they did is they surrendered a grocery store licence for the downstairs premise and applied for a full-on licence for the upstairs. And the theory was the school kids buy their lunches in the grocery store, they're exposed to alcohol, it'd be better to have it in a dedicated shop that minors couldn't enter. So they got their first licence, it was appealed to the authority upheld that, and then it was on sold, and the applicant traded, I think, for nearly 4 years on temporary authorities. The DLC, the renewal, the new application was opposed by the community, high deprivation area in Mangere, and directly across the road is the Southern Campus High School, college, a huge college servicing the area, a church right across on a crossing on the right-hand side. And the authority, the DLC and the authority granted both applications, the High Court turned it down. And what I'd say to you again, totally different factual matrix. It's good law. I don't have a problem with the findings in the law, the legal tests are applied correctly, but the factual matrix, highly deprived community, a school across the road, and proper evidence of issues with the operation of the premises, because it had been operating under temporary authority, mean you've got a different factual matrix again. And then I turn to Bader Street, which is in Hamilton, and again another high deprivation area. I think it was a 9 and 10, so similar vulnerabilities to Whitman Way in Mangere. But what happened there was the applicant, the director of the applicant company, gave undertakings that he would return to New Zealand. He was overseas. So these were legal undertakings given by his counsel to the DLC, and he never returned. He breached 2 or 3 undertakings. And that was the driving factor, saying, well, how can you be suitable and trustworthy and of good character if you don't comply with legal undertakings given to a committee? He wasn't even in the country when the authority heard the appeal. So this is the director, the chap who's supposed to be guiding and keeping an eye on things with his staff. But what I also want to mention to you is it's paragraph, in terms of community engagement, so I think my friend will say, well, this case is authority for community engagement. In my submission, what it says about community engagement is prospective. So this is, I haven't got this in my written submissions, but paragraph 57 of that decision, paragraph 59. Ongoing community engagement is likely to be difficult, if not impossible, to achieve when the primary individual responsible for Dole, Mr. Singh, so the director said, I'll run this business, I'll look after it, but I'm not here, is only in New Zealand for such a limited time. Likewise, engaging positively with the relevant regulatory agencies will be difficult to achieve remotely. So it's prospective looking. It's how would this premise be run in the future? Would this director or this person saying he'd run the business be available to understand his community, engage with it, and engage with the agencies? So it's not about before an application, it's about how does this look in the future? And they said, well, we can't rely on you because you've breached your undertakings, you're never in the country. Makes perfect sense. And again, I say it's a good decision, applies the law correctly, there's no obvious inconsistencies with other decisions of the High Court. Objectives to car parking and traffic issues. This, and I've put the whole quote, and I was almost embarrassed about how much I put in, but the authorities thought very carefully about this. Car parking and traffic are not relevant matters under the Sale and Supply of Alcohol Act. It's just that simple. They're a resource management matter, and Judge Kelly went through the genesis of the Act, and there's more on this in that PKNG decision. The PKNG decision is the main one that's cited in Town Hall, saying it's just not an issue. And it's a very thorough analysis of the background to that. Compatibility, I just cite the Pleasant Point decision. The proposed site was 100 metres from a daycare and approximately 600 metres from a local school. And then I, over the page at paragraph 90, the fact that something that might be incompatible with a sensitive site is not the end of the matter. Just like I say, that, however, is not itself sufficient to determine the application. If the two premises are incompatible, the weight that is to be given to any incompatibility when forming an opinion about what impact granting the licence might have on amenity and good order is a matter for the decision maker based on the evidence. In this regard, Singh Trading is correct in saying that the premises may be incompatible at some level, yet a decision maker may find that the degree of incompatibility is not so significant as to result in a more than a minor impact on the amenity and good order. And then it went on to say this includes, in this case, how the appearance of the bottle store fits with other buildings and residents nearby. Mr. Christensen will explain the use of schist and the materials in terms of this building. The authority also agrees that the assessment of compatibility may in some cases involve an assessment of the potential risk, as the risk of alcohol-related harm may go to whether the uses of the land in question are mutually tolerant. It is this reason, for example, that licences are unlikely to be granted where firearms are in use nearby or consuming alcohol in hot pools. And then finally, it cannot be said simply because the school is less than 100 metres away as the crow flies, it is near the proposed premises. Consideration must be given, as Singh Trading submits, to the premises and the school being separated by a main road, rail trucks, a grass reserve and another street. These factors tend towards the school not being near the premises. And then finally, large signs, dominant advertising and bright garish colours in a predominantly residential area are likely to have a greater impact. And of course we say the livery use and signage is modest here, and others may have a different view, but that is the position for the applicant. And then finally, there are some conditions at 137 that satisfied the authority in that case that the application could be granted despite the fact that there were sensitive sites nearby. Exposure, there is frequent references and evidence to exposure of alcohol to minors. That word doesn't appear in section 105. There's no criterion that says minimise or reduce exposure of alcohol to minors. Interestingly though, it does say that in relation to single alcohol areas in supermarkets. And the reason I raise that is Parliament was clearly alert to the issue of exposure to alcohol to minors, and it dealt with it in relation to supermarkets because minors can enter supermarkets on their own and walk around. It chose not to do something similar in relation to bottle stores. And that's because a bottle store can have a supervised designation, as is proposed here, and only a legal parent or guardian may take a minor into the store. So when we get to this issue of exposure, I think it's important to remember that the issue was dealt with head-on in terms of supermarkets and grocery stores, but was not a criterion in relation to bottle stores. Then at 3.6, I just refer to the decision Humphrey and Cathedral Grammar Friends, where, again, just to bring some balance to concerns, in paragraph 64 of that quote, in this regard, while the Friends group accepts that there is potential for indirect harm of consumption of alcohol by adults in the presence of children, that does not of itself establish that the consumption of alcohol in the presence of children or at events designed for children is inherently inappropriate. And so that case, in my view, indicates that we expect in society where alcohol is lawful, that minors will see alcohol and may see people consuming it. Now, there will be behaviours that are acceptable, and there may be other behaviours or other venues that are not. But the suggestion that a minor, if it is being suggested, should never see an alcohol brand, well, that's probably an impossibility, and the Act doesn't suggest that that should be the target where we should be aiming. Just very quickly, sir, I've got some notes to briefly respond to my friend's submissions, but that's not in writing. I just wanted to do that quickly now, and then we'll get to the evidence. So paragraph 20, so these are Dr. Gordon's submissions of 31 October 2025, so I didn't have them when I wrote my supplementary submissions. And at paragraph 20, she introduces the extended definition of suitability. And I didn't see that in any of the objections. So when you're in a vulnerable community, a deprivation 8, 9 or 10, I accept the standard of suitability goes up. And it's called extended suitability. And there's a test for that, and it's in, but no one here, as far as I can see in terms of objectors, have said there's a particular vulnerability, certainly not deprivation, we can't get there on that metric, but there's some other vulnerability that means the extended threshold applies. So what I would probably say to you is that whatever standard applies, these guys are suitable because they're outstanding operators. But in my view, you just have the orthodox suitability test here. Criminal convictions, trust, character, previous operation of stores, those matters. And what's really interesting too, I should add, is in the Dole decision, or it may be one of those two recent High Court decisions, the High Court is very clear that suitability is a separate, discrete criterion. You don't bring amenity and good order into it, and you don't bring other matters into it. You look at that on its own, being guided by those principles of character, honesty, transparency, and so on. So I'm not sure what evidence my friend relies on to say we were in this highly deprived, vulnerable community such that the elevated extended definition applies. As I've mentioned, there's a submission that you can't assess the building because it's the 100F, because the building hasn't been built yet. But I say, yes, you can based on the plans. But ironically, on the one hand, my friend will say you can't assess the building, but then she also says that the building will dwarf the property, that paragraph 22, will dwarf other properties and will dominate the housing in the area. Well, you can either assess the building or you can't. So you can't have it both ways. And if you're going to say it's going to dominate, then you must be using some information to draw that conclusion. And if you can reach that conclusion, I think you can also say, does it have appropriate glazing? Does it have the shelves in the right place? Is there a problem with the design and layout? So my submission is an inconsistency there saying we can't assess the building, but I'll tell you the building's going to dominate the community. You can't have it both ways. And then finally, in terms of CPOs, Mr. Christensen has addressed those. The CPOs that are referred to in relation to other stores in my submission aren't relevant to this store, to this application. But as I say, both CPO failures are acknowledged and the response to them and the circumstances around them are addressed by Mr. Christensen. So, sir, thank you for your patience, but unless there's anything more you need from me or any clarification, I will move on to the evidence.
Right, thank you, Mr. Young.
Thank you, sir. I propose to call Mr. Christensen first, so we'll get him sworn in, then I'll get him to confirm his evidence, and then I'll hand him over to you. Christensen, do you have a statement of evidence in front of you dated 24 September 2025?
Yes, I do.
And can you confirm that that evidence and the attachments to it are true and correct to the best of your knowledge?
Yes, I can.
And do you have a rebuttal statement of evidence dated 28 October 2025?
Yes, I do.
And can you confirm that that evidence and the attachments to it are true and correct to the best of your knowledge?
Yes, I can.
Thank you. Please answer any questions.
Thank you.
Oh, sorry, you'll just do a summary. Sorry, I apologise. Mr.
Yeah.
Summary.
Thank you. I was just asked to put a wee summary together. My name's Glenn Christensen and I'm the Group CEO for the Gate. I was initially employed in 2005 as General Manager, and at that time we had the Golden Gate Lodge and 3 super liquor stores. As it's grown, we've taken on the Glebe Apartments, the management rights, and 2 additional bottle stores. We've altered our business model to allow for additional senior management to help us run our businesses. We take the sale and supply of liquor very seriously. We take our responsibilities for responsible sale and supply and the reduction of harm as a priority in our business. Just want to touch on special housing or affordable housing and my knowledge of it. Just need to note that I was the inaugural chair of the Central Otago Affordable Housing Trust, which was put together by the Mayor, Tim Cadogan, and Stephen Brent, who was the chair of the Queenstown Trust. So I am aware of affordable and social housing. We tried to push through the secured home scheme. Unfortunately, the council at the time didn't support that. We're based our decision to build in Lake Hawea based on information given to us by Tim Williams and the perceived growth and the history of Hawea. We have a strong business sense around starting with communities and growing with the communities. That was evident with Cromwell, also with Queenstown when we went into Remarkables Park. I don't believe that Hawea today will be the same town in 5 years or 10 years' time. We're used to working in areas with seasonal trends, Queenstown with tourism, and of course Alexandra and Cromwell with horticulture and viticulture. I'd like to acknowledge concerns regarding exposure. However, we run a supervised licence, so if young persons wish to come on site, it will be with the support of their parent or legal guardian. We do have strict ID procedures and group exclusion, so if we believe someone is underage, then everyone is excluded. I do enjoy my community involvement, and I encourage my managers to get involved where possible. My directors, Alan Mackay, have empowered me over the last 20 years to support various causes and activities through cash, kind, and my time. I do believe that Hawea and Lake Hawea will get a bottle store at some point, and that we are the suitable operator due to our great history, our strong operational standards, which are held by our staff and guided by Superliquor Holdings. That's my short brief, a lot shorter than John's, and I'm happy to take any questions.
Yeah, thanks for that. It was touched on, and we've read a bit about it, but this issue of what the building's going to look like, and from the outside, we just heard talk about, 1 minute people saying it's going to dominate the area, but we haven't actually got the plans. We've seen sketches of it. So, for example, out-facing windows, what's the planting and things like that? What will as you're driving down the main road, Capel Ave into there?
Yeah,
Longview Drive into there.
Yeah.
What are you going to see from the outside?
So what you see in our plan and our proposal is what we intend to build. Very, very much what you see there. The strong schist represents Central Otago. You'll see that we've put some nice fencing through there. We have a history of good building, so if you want to see the upgrade that we've done to the Harvest Hotel in Cromwell, we intend to build to that high standard. It's important that we build to a high standard so it stands the test of time. You'll see that it's only 1 story high. We envisage that when you drive into Longview in time, you won't see our building because we'll be surrounded by additional commercial properties. So we will be the first commercial property for sure, but we will soon be surrounded by other commercial properties.
Okay, thank you. Now, I think you have clarified it, but there was some people's perception there was going to be some sort of alcohol store drive-through. Now, you've explained there's a canopy thing. Can you just clarify exactly what you mean by the canopy?
That is exactly that. We call it a drive-through. It is a canopy. That's where you drive in, you can park your car, and you don't get wet, and you go into your store. So it's not driving through the store.
It's not like you drive through up to a window and...
Correct.
Okay, cool. Some of the other stores, if you've got, we hear about activities that are vulnerable activities, like we have churches next door or playgrounds or schools and things like that. So some of the other stores, if you've got playground, like Alexandra, I think it's a playground, was it there before your store or after the store?
I'd need to refer to Alan on that one. It's been there as long as I've been there. So 20 years that I've been involved, the playground has always been there.
So do you have you got any, as a CEO, you've been receiving any, over the years, complaints, problems from, say, like in Wanaka, the New Life Church, right next door to it, to your store? There's a child learning centre across the road. Have you been receiving any, from those organisations, any complaints or comments about your activity?
No, we've had 0 complaints from our neighbours. to our staff or to me directly. That includes the church, the gym next door in Remarkables Park, and the playground in Alexandra.
Well, that's all from me at the moment, thanks.
Thank you. Just the span of hours that you're talking about doing here, 9 till 9, 7 days a week, and rostering that type of shift. Could you just enlighten us a little on how that's going to happen?
Yeah, so we believe it'll be a similar ratio to our Wanaka store, and I included a copy of our roster. So we generally have 2 staff on. There is times where we only have 1, and that's just when we're opening and when the demand is. You'll see that on a Thursday, Friday, Saturday, we potentially have the 3 staff on through those busy periods. So we still have to cover breaks and work along those lines. So
I understand you've got a number of outlets, and it was a concern from a number of objectors, that span of hours. Was it absolutely necessary? I think some of the questions were based around the exposure that a store had to open at 9 a.m, for instance, as opposed to midday. Is that simply a business decision, or are you talking about deliveries arriving at that time? It's just filling in the gap for me.
Oh, that's our licence condition. So deliveries have been requested through our consent process to be first thing in the morning, and then we just believe it's a business decision from 9 to 9. However, we have taken on that feedback, and we are happy to review ours where possible and if possible.
That's right.
Probably based around seasonality, to be fair with you.
Thank you.
Could you confirm that you agree to a condition there'll be no RTDs or single sales?
No mainstream beers and RTDs is what we agreed to.
Sorry, what do you mean?
No mainstream beers as single sales or RTDs as single sales.
So you're happy for that, if the licence is granted, for that condition to be imposed?
Absolutely.
Yeah. Thank you. That's all. Thank you very much.
There's one more. I'm not sure if you're the right one, but just to clarify, what if the licence was issued? What is you indicated a time frame for development out there, or what of timing of building and things like that?
Yeah, look, we think it would be a 12-month process. That's just a matter of once we get approval for the licence, we'll just start going through the process to build the property. So
as soon as you get the licence, you'll start the building consent
start that
process.
process and get the property going, yes.
Okay, thank you.
Thank you very much.
So I just have one matter in re-examination, if I may. I know I can't cross-examine witnesses. Just one clarification point.
Yeah, of course.
So if I can take you to the bundle in the inspector's report, page 18 of 46, and there's a plan there. I just want to put it in front of. This relates to the questions around the other buildings from Member Cox, and I just thought this might be helpful. Have you got that? So there's a big star where the premises are proposed to
I
be.
have seen that one. I know the one you mean.
Now, Mr. Christensen, you'll see there Riley Street, and there's a vacant block. What is your understanding of the zoning of that land?
Commercial.
And are you able to indicate if there is any other commercial land zoned in and around your site?
Opposite the other side of Burden Loop Road.
Just to the committee, so they.
Just to the top side of Burden, directly opposite us on Burden Loop Road, and also the top side of Riley Street.
And so over time, the block of land within which you're situated, the adjacent block of land by Riley Street and land above Burden Loop will be developed for commercial activities.
Correct.
Thank you, sir. So I'll move on to my next witness, sir. I'll call Mr. Hoare, who Mr. Christensen's going to stay with me. We'll sit down the end here. Oh, yes. sorry. Now, Mr. Hoare, I'll get you to confirm your statement first and then you can do your summary, but do you have a statement of evidence in front of you dated 24 September 2025? And can you confirm that the content of that evidence, including the attachments, is true and correct to the best of your knowledge? I do. Sir, just one thing, Mr. Hoare does have some A3 mock-ups, bigger pictures of the premises, which we could hand out for everyone now, just it's a bigger version. And he could introduce them, so we've got an A3. How many sets do you have? How many sets, sorry? Just 2 pages. How many sets of them do you have? Oh, okay. Sorry, so, well, actually, we only got 2. We might pause that until we've got enough for everyone else. So, we could share, well, we can one to the objectives so they can see the image, and I can hand one up to you. I won't approach you, but sort of through the maybe we call it exhibit A. And we'll make more copies available to the other parties, sir, but it's just a bigger version of the image that is in various, but it's in Miss Riley's evidence, it's in Mr. Christensen's evidence. So thank you, sir. I'll now hand over to Mr. Hoare to do his summary.
And also to answer any questions. As my said, my name is Greg Hoare. I'm the National Operations Manager for Superliquor Holdings. I've been in the industry since 1993, working for various breweries. I reside in Christchurch, and part of the territories I have worked in the past includes this area, so I know the area fairly well. I've been employed by Superliquor Holdings since 2015. I really just want to draw your attention to probably 3 or 4 pieces in my evidence. First of all, point 2.5, the position of Superliquor Holdings in the market. As being one of the larger liquor banners in New Zealand, we don't take this lightly. We have the utmost regard to the Sale and Supply of Alcohol Act, and I hope the detail in my evidence reflects this, particularly in the areas of compliance, our brand standards, which I'll talk about soon, our franchise manager involvement in our franchisees' businesses, our training, and also our robust application process, and also our solid franchise agreement. And we take the Act very seriously. We take our business very seriously. If people don't abide by the law, termination can result. If I now refer you to section 2.9, as far as a business, we take the responsibility of minimising alcohol harm also very seriously. As a business, we do a lot in this space. We've got a lot of various policies that we've introduced into our business over the years, and that includes pricing, how we market brands to the market. We also have a thing called a banned product list, which basically on that list is it's a product we deem is not appropriate to a market. Our franchisees are not allowed to sell those products. We also have retainers for some of the key areas in our business, and what I mean by that is we retain the services of two legal firms. One is John Young's Brookfield's lawyers, so it means that at any time our franchisee can call free of charge and a direct line to John Young that we pay for the services, but it gives the confidence that we want to ensure that our franchisees are abiding by the law. So if they're not sure, if they have an instance where they want to ask the question, they can pick the phone up, drop John an email free of charge. The other legal company we retain is the services of Lane Neve, and that's for employment law, health and safety, also immigration. So it means that, once again, to ensure that we are doing the right thing, our franchisees are doing the right thing, they can contact Lane Neve, for example, it could be for an employment agreement, to ensure that their staff are operating with the latest policy and provisions. That means that they can ring Lane Neve, ask them to email them a copy of the latest employment agreement, free of charge. We pick up the cost. So it's not something that we say, at Superliquor we do, so we're pretty proud of that. As far as the design and layout, the building that is represented on that A3 piece of paper is designed with the community in mind, and this is something where the Gate Group with Glenn Christensen and the operations manager Michelle, myself and Linka, our franchise manager, have sat down and actually spent quite a bit of time looking at the design, the signage, the footprint inside, where should different categories go. So with design and layout, we don't have an issue with deprivation. We've looked at what we think the sales mix would be in store and designed a store that we think looks really good. If we look at the Lakes District, and if you look at that store, we think it fits in really well. And once again, we're open to suggestions from yourselves, objectors, to say, you know, for example, signage. So what we've done is we've actually toned down what we think. We also, with the design and layout, we don't allow any supplier to put a brand in our building, so you won't see the big brands or small brands, wine brands, spirit brands, beer brands on our building. It's Superliquor and Superliquor only, which we think is a good thing. We do allow product and price if the conditions on the licence allows, meaning that we can have a Steinlager beer at, for example, $44.99 in a window. But once again, that's based on conditions as well. So we're very much open to suggestions from the DRC in regards to the look and feel of our building. But we think we have delivered something in design that's pleasing and fits in with the community. If I can draw your attention just to the appendices, or point 7, and also the appendices about the training that we have in our and it's something that my team and the company has spent quite a bit of money and time on to develop, that we think the training, and if you look at the appendices, it just gives some snapshots of the training that we provide, and we believe it's the best in the industry. It's very thorough, and we think we've got very good checks and balances in place. So the training you see is not voluntary, it's mandatory, so every serving staff member has to complete training at certain times through the year, and that's checked by producing certificates that our franchise managers basically check on. So what we do is we have very good training. We've got 18 modules that we've got Steve McDowell, an ex-police officer, ex-council member in Auckland, to develop our training with us. So it's really good. It's interactive in the sense of video, reading, quizzes and certificates. And what we're also doing is we're about to launch, we've just worked through a program that we're about to launch, mystery shopper programs, to be paid for by Superliquor Holdings, to do 2 checks on every store of 190 stores twice per annum. One of the other things too is we've just brought to us today our managers folder. This is something that we've incorporated into our business over the last 8 or 9 years that basically keeps everything in one spot. And we welcome agencies who visit our stores to actually ask for our managers folder, to have a look, and that's got our managers to register, our training, our rosters, all those type of things all in one area. And then we also have an incident book, and we've changed ours to an incident communication book because we really want to encourage our franchisees and staff to use this for anything that happens within their business. So once again, we have this open. These are kept usually at the counter, and as an added protection, if you like, just to make sure the staff and owners are using these documents, we have Linka, our franchise manager, who, when she calls on a quarterly basis, will take this and stamp it. So you'll see through here there's stamps that things are being checked on. So I welcome, if you'd like to see those, I'm happy to pass those around. So once again, I just really want to reinforce, there are companies out there are banners out there that say they have training. Hopefully the information I've presented to you does give you the confidence that we're doing our best. And finally from me, the directors, management and staff are extremely professional people. We take our applications seriously. We turn down approximately 25 to 30 applications or expressions of interest as a business nationally per annum, and that's something that we take very seriously. We only want the best working for us, and we took on board about 2 years ago, we got questioned whether we were doing Ministry of Justice police checks, and it's something we hadn't thought of, but as a result of that advice or idea that came from a chair from a DLC, we've taken that on board. So about the last 18 months, we also do police checks on every applicant as well. The applicants before you today are generally care, and I think that's important. They generally care about what they do, how they run their businesses, and more importantly, the communities that they are involved with. So once again, thank you for your time, and I welcome any questions you may have.
Yeah, thanks for that. I'll go a couple of questions, but this firstly, you mentioned something about the store advertising in windows. Now we've struck this on other areas where it can become a bit of a problem. I'm just not understanding, and some of the others have been sort of directed by their hierarchy that we want you to do this. How do you handle that? So look, some of the, the idea of the, say, visibility and things, would you be expecting signage of various suppliers in the windows of the store or not?
So categorically, there's no supplier that can have their brand in the window just by itself. We say we're clean sites, anything forward-facing from on the window or on our buildings is a no-go. There's a number of LAPs, actually practice notes. So Auckland, for example, have a no product and price policy in the Auckland market, and that's coming through the country as well. So as far as a condition on licence, if you place a condition on the licence to say there must be no product and price on the windows or on the exterior of the building, we'll comply.
Okay. Getting to this hearing, and you obviously deal with licensees all around the place. Have you had a hearing like this for one of your stores before?
Yes, sir. It's something we pride ourselves on. We're here to support our franchisees. People go through a rigorous application process. If they get through our process and do come up with either a renewal or a new licence, we'll stand by them.
Okay. Have you had a hearing where there's been lots of objections, like, and have you had the pro forma type objections come in?
Yes, sir. We've had objections where we had one recently in Christchurch and New Brighton and Seaside, heard community objection, which we worked through, and we actually understand that. We want to be part of the community, so we actually embrace that and actually want to talk to community. So, but saying from the original outset of 500, I haven't experienced that before, but within the 20s, 30s that we've experienced today, there are people attending, we have.
Okay. You mentioned in your paragraph 219 about the engaging with the health promotion agency. You're still engaged with the health promotion agency? Is that still happening?
Yeah, Mark Lynn was the person, about when I started with Sinead, one of our internal people, got involved with the online program, was involved, so we don't actually have any direct relationship with them. But what we have started over the last 2 years is that trying to engage all the tri-agencies, police, medical officer of health, and liquor licensing through the country. So I probably catch up with Mr. Paulin, or Sergeant Paulin in Dunedin, probably twice a year, and we've run various things through Waikato, Rotorua, Christchurch is rush, it's good, but as far as that particular instance, no.
Okay. We used to run in Queenstown. I think they're trying to establish again a licensee group where they all representatives from various outlets get together with the police and the agencies and try and work together. Is that, do you know if that's happening? Have you involved in any of that in Alexandra or Queenstown?
We value that, so we'd love to be involved in that. So what we try to encourage with our franchisees to be involved in a resident association, a business association, and if there is a liquor accord, we'd love that. So that's something that whether we are the best person to run that, as far as the franchisee, I don't think it's the right for the franchisor, us running it, because of we kind of are remote from the area. But what we would encourage that Glenn, and we've had the discussion with Glenn, he would be involved in that type of thing. So if I'm hearing you right, get together on, off licences, if police want to be there, liquor licensing, and maybe catch up to discuss any issues. Could be from litter or peak season coming, what do we want to do, those type of things. Yeah, let's discuss it, and I'm sure Glenn would be involved.
Okay, thank you.
Member Cox, Mr. Christensen might be able to.
Yeah, no, so I realise now I must be asking the wrong.
No, that's all right. I think both are. But if you're happy, sir, Mr. Christensen might be able to expand a bit on that question, if he can respond.
Yeah, the alcohol accord meeting for Queenstown was about a fortnight ago. Our manager from Remarkables Park attended. The alcohol accord meeting for Central Otago was today at the Five Stags. So They are ongoing.
So was Wanaka not included in these accord, or do you have representatives from Wanaka?
So Hospitality New Zealand initially led the alcohol accord, and it's just looking to move over into Wanaka at some stage. So Brendan Elliott, the representative from Hospitality New Zealand, I believe works with Sean on that.
Okay, thank you. Thanks, Mr. Chairman.
Thank you. Just with that, are all your franchisees members of the Hospitality Association?
No, they're not. We joined Hospitality as a business probably about 6 years ago. It's more on-premise focused rather than off-premise focused. So what we are members of now is ABC. It's basically the Alcohol Beverage Council, which meets every Thursday at 9 a.m. by teams, and that involves all the major brewers and most of the retailers to talk about any issues in the area. So that's done at kind of a corporate head office level. But we're also actively involved in other areas. But as far as the Hospitality Association didn't kind of work for an off-premise, we didn't believe for us.
We got some feedback, concerns about potential for pricing wars if things get tough and disorderly marketing. With how much autonomy does a franchisee have? What chances are there that a franchisee in an applicant with this licence could act independently on a pricing issue or something, responding to something else that's happened in Hawea?
So if I can give you just a brief overview of
Sure.
how it would work. So an average superliquor store would have about 2,000 items. Of that, about 450 of those items are made up by superliquor holdings, what we call a core range. And the importance of a core range is to ensure that we can put an advertising program together that we know every store must have. So out of 2,000 products, 450 we know is in every store. And other big brands, Heineken, Steinlager, Johnny Walker, Gordon's, those type of brands. So we set the price for the promotional program, but of that, the store owners dictate what they want on their normal everyday, what we call white ticket pricing, or if those products of core range are not being promoted, they can decide what they want. So it gives them flexibility. However, to run a bottle store, each applicant fills in a profit and loss statement of their expected GP, expected sales. It's not my experience with the Gate Group, as I call them, that are the applicants today. They're not price fighters, and nor a Superliquor. So, as you can see from the photos, we're more about customer experience, service, range is important, and customer service. So, you have to be competitive because of, to be honest, supermarkets will be the cheapest in the market in wine and beer. So you have to be competitive, but we're a long way off that. So competing with the supermarket.
Thank you.
So many more expensive.
Thanks.
Just a clarification on advertising, on-site advertising. You mentioned the windows. Do you put adverts inside the windows?
So that's something, sir. If you said there is to be no advertising on the windows, we would assume from you you're meaning either outside or inside facing.
Inside.
Yeah.
Or outside either.
Yeah. So what we'd say is no to that. We had an instance in Auckland where, and this is just where I suppose it needs to be sure on the same wavelength, in the sense that in Auckland, a superliquor had a condition for their licence, no outward facing signage. So we took that as no sign to be put on the glass inside to look outside, and that's how we'd operate. However, we had a liquor licence inspector who said, no, it means every ticket in the store can't be front facing, and we said, no, that's just not right. So that was sorted through Rob Abbott to say, no, the intention of the condition was to say nothing on the inside or outside of the glass, stuck to the glass. So if that answers your question, sir.
And there's no other external advertising?
So at the moment, we allow
Just
product
the
and price.
superliquor side?
So at the moment, we allow product and price, and it's something that if you said to us, sir, there is to be no product and price on the windows, whether on the outside or facing on the inside, we would talk to our franchisee and say, we think that's appropriate if that's what you want. So we would take on your recommendation and talk
That product and price is just standard font, no branding. So just black lettering, that's what you're talking about in terms of external?
No, so what
Sorry?
I meant, is, so definitely there, on our buildings, there is no Steinlager Heineken just sitting by itself on a flag or a painting or a picture on the building. What we allow is potentially a picture of Steinlager 24-pack at $49.99. And we allow that, but it's limited a number. We wouldn't be
Where will
plastering
that
up.
sign be? Sorry.
Sorry, sir.
Where will that advert be placed?
So if you said today that we're happy with the applicant, but we do not want on the window, then we would not have that on the window at all on the site. So normally what we would say, sir, is that it could be on the building or on a window that clearly says a product and price. However, we also have, don't forget Mother's Day. It might be just a mention. It might be, say, Christmas is coming, don't forget your Christmas gifts. So it may be a message like that. So not always is it product and price.
Sorry, I don't want to labour it, but I am.
Sure, no.
External advertising, you would permit your franchisees to do that?
If it's not conditioned on their licence, we allow them to do that. But only product and price, not generic branding of new brands and bollard covers and all that type of thing is a no in super liquor.
Okay, thank you. Thank you.
If it would help, sir, if I can add, if you'd like to see what I mean by that, I can print something off tomorrow and show you what I mean, if that would help. Would that help? Sure.
So I just have one question, re-examination, just to flesh the matter out. That's all right, sir?
Beg your pardon, sorry.
I just have one matter in re-examination, just to flesh a point out, and one clarification. You mentioned the HPA, and you gave an answer that we did some online work. Can you just explain what that was and the project you engaged that Superliquor were involved with? Was the HPA?
It was actually one of our administrators in the Auckland office, Sinead Stanton, who right at the start got involved with Mark Lynn, and was involved in looking at the application, how it would work in a retail environment to get the best product on the market, if you like, to train serving staff and off-premise. So once that model was done, it's live, we haven't engaged again because it's set up and running.
Was that Serve-wise?
That's Serve-wise.
That's what I was hoping you
I
did.
apologise. Yeah, Serve-wise. Yeah, thank you.
And just in addition, sir, Mr. Christensen could confirm that all his stores are members of Hospo NZ, and I can give you a little background on that. I used to, we act occasionally for Hospitality New Zealand. Many moons ago, we looked at seeing how they could reshape their business to target off licences, and Superliquor were the first group we sort of looked at, and it's the way they run their business. Mr. Hall's right, it's really on licences that are in their sweet spot, but they do have off licence members, but a lot of their training and stuff sits more company in the on licence space. But if you want to confirm that you're
Yeah, we're all members. I was fortunate enough to be on the National Board of Hospitality New Zealand for a number of years, and am currently the president of the Central Otago branch. So, yeah, we've got our stores and of course our Harvest Hotel, Five Stags, Forage, all members of Hospitality New Zealand. We love the service, we love the opportunity, we love their job descriptions, their employment law and their advisory template has been good for us as well, along with being supported by Superliquor Holdings.
And Sir, if I can just add to that, if our store owners would like to become members, we have no problem with that. It's just, I think we've gone down the track of having retainers for two legal firms that we think can give us advice that best suits our business and maybe our channel. So we're definitely, probably within our group, we may have 10 or 15 members, but yeah, we don't stop people not joining.
I should just clarify one matter. Mr. Hall was kind enough to say that people can ring me for free. Well, that's not quite true. Superliquor pay, it's not pro bono work, but they are able to ring me, and I'm in a privileged position where Superliquor pay that retainer at a set fee, and I take calls and will help people with issues as and when they need. I don't do that for anyone else.
And if I can just add there, it does become a user pay system. So the first piece of advice is covered on the retainer. If they then want to take it further, that then becomes a franchisee cost.
We get the picture.
Thank you, sir. I'll call Ms Given to give her evidence now.
Would you like to swear by oath or affirmation? Do you solemnly, sincerely and truthfully declare and affirm that the evidence you're about to give, touching on the matter before this committee, will be the truth, the whole truth and nothing but the truth? Yes. Thank you.
Ms Given, do you have a statement of evidence dated 24 September
Yes.
2025 in front of you?
Yes.
And can you confirm that that is true and correct to
Yes.
the best of your knowledge?
Yes.
Thank you. Do you want to do a summary or would you happily just move to questions?
I've got a short summary.
Please do your summary.
I'm Michelle Given. I've lived in Cromwell for 32 years. I'm in my 24th year working for the Gate Group. I was offered the job managing the Super Liquor Alexandra store in 2002. I managed for 15 years. I was then asked to step into the role of regional manager in Cromwell and managing the Cromwell store. I'm extremely passionate about Super Liquor and the Gate Group. Our director is a very successful businessman. I've enjoyed working alongside Glenn and have learned so much from him. It is a well-structured company. I enjoy my role and work with great people. We have great training. Our staff will be trained to be professional. We have in-store training as well as the Super Liquor. I like following the Super Liquor training. It's very structured and easy to follow. They are very, very supportive. And I'm happy to answer questions.
Yeah, just on staffing, looking at, you've got all the stores operating around the region. Do you have much difficulty getting good staff and qualified duty managers? Is there a problem there, or is it manageable?
There is problems. Sometimes we have big problems, like we can run very fine on staff. It just depends on who's in the area. People that have not done retail can't go in and just get a duty manager's certificate. They've got to be within the business for 6 months. But we support them, we give them all the training that we can. And we make sure that all our staff are well trained before they're behind the point of sale. We put them through their armed hold-up courses, we put them through the online SSAA 2012 course, serving minors. We make them read and sign the staff acknowledgement form. And we have more of our staff with duty manager certificates than what we don't have. So,
Okay. So have you not, what about the concern of having another store, having the staff for that? Are you confident? Yeah. What happens if you don't? Do you just have to close the store?
No, I'm more than capable of coming up and getting behind a till.
Will you rove as a backup?
Yep, absolutely. Any issues in any stores, any shortage, I rove round.
So if there was another store in Hawea, you're quite confident that you can man it appropriately?
Absolutely. We've got two good staff in Wanaka now, and both of them are moving out to live at Hawea. So
So what do you do with Wanaka?
we'll staff that also. They'll
Okay.
probably rove between the two and hire other staff. We've got good staff in Wanaka now backing up Tash and Britt.
Thank you.
Wasn't too bad. Finally, I'll call Mr Mackay.
Would you like to swear by oath or affirmation?
Oath's fine, thanks.
Do Do you swear by Almighty God that the evidence you're about to give, touching on the matter before this committee, will be the truth, the whole truth, and nothing but the truth? Thank you.
Thank you, Mr. Mackay. Before you do your summary, do you have a statement of evidence before you dated 24 September 2025?
I do.
And can you confirm that's true and correct to the best of your knowledge?
It is.
Thank you. Please provide your summary.
Okay. Thank you. My name's Alan Mackay. I'm one of the directors of the Kiru's Gate Group. I don't have a great deal to say other than that we run a very large and successful operation, and you'll be well aware that that entire operation is carried out under licences under the Sale and Supply of Liquor Act, and as such we take that very seriously. Our whole business depends on it. We now have, over the last 25 odd years, gained considerable experience, and we have extremely competent people running it for us. You've met both Glenn and Michelle today. They've worked for us for probably 20 years each, and they've been tremendous in terms of running our business. And we have the greatest respect for them and confidence in their ability. In terms of governance, they report to us regularly, and as I say, we take everything they say and tell us very seriously. We try and keep the best systems we can in our business to make sure that everything runs smoothly, and most of the time it does. For Hawea, we're proposing what I consider to be an attractive, well-built premise. We're putting it in an area where there's going to be considerable growth. It's right smack bang in the middle of a commercial area, and we think that it will eventually complement the area. We do understand communities. We support communities, both personally and through our business. We think we can work with the community to satisfy the people who object to the business. I think the establishment of our store out there may well be the catalyst to see further growth within their commercial area out there and attract other businesses. You know, it takes a bit of confidence to put a new business in the middle of a vacant paddock, but it is a commercial area, and what we're doing, I think, will attract other businesses, which will eventually help that community. So we know it upsets some people, but we think that it will eventually be a benefit, and we will be doing it right. So that's pretty much all I want to say to you. I'm happy to answer any questions.
Thanks, Mr. Mackay. Yeah, one of the things that has obviously been raised a few times, and you've not acknowledged it in your thing on at 3.2. So just clarify, you don't own the site yet, you've got a conditional offer on it subject to getting a licence, an off-licence approved, is that correct?
That's correct.
So you've got a sale and purchase agreement all signed up with that agreement?
We've got a sale and purchase agreement to purchase it, and the only outstanding condition, there were other conditions, but the only outstanding condition now is the granting of the licence. Upon the granting of the licence, we will then, as a normal commercial practice, pay our deposit and proceed to settle it in terms of the contract.
Okay. Okay, so if it's not granted, then that deal's off, basically?
No, and I think that's good commercial sense in terms of the way we run our business. There's no use ending up with a
No, I
section.
just wanted to clarify,
Yep.
and that's, I think you've
Thank you.
done that very well, thank you.
That's fine, I'm happy. All good?
Just, thank you, sir. So that's the evidence for the applicant. I don't have any further comments to make unless there's any clarification or assistance I can give you. That's our evidence, and wait to hear what else and move to closing at the appropriate time.
Yes, because you'll have the opportunity to make final submissions.
So I will address,
Written submissions.
yes, so that, I understood that from your minute, that
Yeah.
submissions closing would be in writing at some time.
Yeah.
Normally, the opposition parties would close first and then I would follow with the final say, but we can get to that timetabling when we do. I may just, if you're comfortable with it, make some closing comments generally at the end of the hearing, but we'll see where we get to.
Yeah, yeah.
Thank you, sir.
Thank you. Now, the Ministry of Health, are you ready to give your evidence today?
Thank you, Mr Chair. I'm not prepared to give evidence today. That was a change this morning, so I'm expecting the original agenda, which was to give evidence tomorrow morning.
Okay.
Thank you.
Dr. Gordon, would you like to give your evidence today, or do you want to wait till tomorrow?
So, sir, what you're proposing is that I give my opening and then we go back to the schedule and start off with the medical
course,
officer health
yep.
in the morning
Yeah.
and then the objectors.
Just if it's convenient to you, I mean,
Well, I think the thing is that I'd like to give my opening straight before my clients.
okay,
Normal practice.
tomorrow.
So that means that it's.
Oh, that's fine. Okay, well, thank you, everybody. We'll convene tomorrow at 11 o'clock.
Thank you.